argument. He used a relay analogy, an athletic analogy, talking about a relay and how a baton is passed from one runner to the next, suggesting that Oscar Pistorius, in his words, had dropped the baton of truth, and on the basis of that, his version had to be dismissed out of hand.
Absolutely. He said in this particular relay that he's been using throughout his closing argument was basically this trial, and basically he's saying that he should have been disqualified from this relay. He dropped the truth several times. He stumbled across it, and he's brought up various instances of where he changed his version, even during his own testimony, especially during cross-examination, just changing certain words, becoming confused, bringing forward two sets of defences, which is what the state is focusing on. How can he bring forward two sets of defences in this particular instance? And they're saying that it's just inevitable. He cannot escape conviction on this particular trial.
Gia Nicolaides of the Eyewitness News team, as always, thanks very much indeed for your insights. More from Gia when court resumes tomorrow. But it has, as I say, as far as the defence is concerned, become all about timings. And when we resume tomorrow, I guess we'll get more of an insight into exactly how they intend building their case around timings like 3 o'clock in the morning, 12 minutes past 3 in the morning, 17 minutes past 3 in the morning, 19 minutes past 3 in the morning, and on we go. But these timings are absolutely crucial to the defence's case. As I say, more on that theme tomorrow. Still plenty to come from our position here in Pretoria. For now, it's back to Bongani in studio.
John, thank you very much for that analysis and discussion with Gia Nicolaides. Of course, as promised a little earlier, I am in the studio with top legal minds, and that's, of course, former Zimbabwean High Court Judge Chris Greenland and defense attorney Ulrich Roux. Gentlemen, once again, welcome to the studio.
Thank you.
I mean, there's so much to discuss. It's been such a compelling and absorbing day. I keep repeating myself, but let's just look at some of the key points that we've seen raised today. And before I go anywhere else, I suppose, Judge, let's start with you. This issue of, directus eventualis, dolus eventualis and dolus directus, please explain some of that terminology for us and unpack it as to why it's relevant here again.
Bongani, you'll excuse me, but I'll rely on my colleague. Ulrich will explain it to us. What I want to say is that we've come to the point it's a conclusion of all Nel's efforts. John Webb said that Roux is in full flight, and I would say that Nel has made a very nice landing in concluding his arguments. And in a very calm, dignified way, he submitted to the court that Oscar has to be convicted of murder on the basis that his story, his version, has to be rejected. Because for any number of reasons, he was a vague witness, he was argumentative, and most importantly, he was guilty of striking mendacity. And he has said that the idea of a perceived intruder, once that's out of the window, the whole defense falls flat. So his first submission is that even, and we must understand this, even if the court, is unable to say that the state has proved how or why the murder was committed.
Or the killing, rather.
The killing occurred. He is guilty of murder. And this is important for the public to understand. The state doesn't have to prove why. The state doesn't have to prove motive. Gerrie did proffer a timeline as to how the murder did occur and why, as regards them, by saying that they must have been awake at the time, and there's an inference that they had a quarrel. But it's important for the public to understand that the state doesn't have to prove that. It only has to prove that Oscar pointed the weapon at Riva, shot and killed her without legal excuse. That's all it has to do. So that was his first point. And his second point was that even if you accept Oscar's version, he is still guilty of murder, as opposed to, let's say, culpable homicide. He's saying there's still intention, and Ulrich is going to explain why that is so. From the public's point of view, it really boils down to this. You can't just shoot an intruder. You can't just execute an intruder. You cannot shoot or kill somebody just because they are in your house. You can only shoot somebody if you are actually under imminent threat of serious injury or death.
All right, Ulrich, let's pick that up then. I guess it does go back to this question of dolus eventualis and directus and all of these terms. Explain then, has Gerrie Nel made the point that the judge is saying he did?
The judge is certainly putting me on the spot here. But when one looks at the charge of murder, there are 4 different variances. The first is premeditated murder. Then you have murder directus. Then you have murder dolus eventualis and murder dolus indirectus. Now, premeditated murder is where there is a plan conceived and that plan is executed by the accused. I'm going to give a quick example, and I was actually involved in this case. I had a client who he was involved in a relationship. His girlfriend had gone to study at the coast at one of the universities there, and he had heard that she was having an affair. After hearing this, he went to an unlicensed firearm dealer. He purchased a firearm. He bought himself a bus ticket to where she was studying. He rented a room in a guest house. He looked at her while he conducted surveillance on her movements over 4 days. And then after 4 days, he waited for her as she finished classes and entered her residence. And he shot and killed her. Now, clearly, there is a plan. It's a derived plan. All the steps have been put into place, and he acted according to that plan. Now, there is no definition in our law of premeditated murder. There is no definition in our acts. But people do get convicted of premeditated murder. And the important thing surrounding that, and the difference between premeditated and normal murder, is that with premeditated murder, the court can sentence a person to life imprisonment. Whereas with murder, that is the minimum sentence. With murder, the minimum sentence is 25 years. Where that comes into play is when a person receives a life sentence, he can only apply for parole after 25 years. When he receives 25 years, he can apply for parole after 12 years. So that is the big difference between premeditated and murder. Now let's go on to murder directus. Murder directus is where a person acts in a certain manner. He knows that if he acts in that manner, someone will be killed, and he acts accordingly. Now, what Gerrie Nel pointed out in his argument today is there is no significance in an error in persona. In other words, whether it is an intruder behind the door or whether it is Riva Steenkamp behind the door, there is no difference. He still wanted to kill whoever was behind that door.
Ulrich, I'm going to have to stop you there because we need a little bit more time to unpack these concepts. So before we continue with that, let's have a look at some of the highlights that we saw today. Welcome back to Channel 109. It is day 40 of the Oscar Pistorius trial as the trial enters into the first day of closing arguments. In studio with me, of course, our top legal minds, Chris Greenland and Ulrich Roux. Ulrich, I'm going to start with you because before we showed you we showed some of the highlights, you'd already explained what premeditated murder was. You were then about to explain, or in the middle of explaining, how somebody might kill another without perhaps planning to, but nonetheless do it intending to do so.
Yes, indeed, and that is what we refer to as murder dolus directus. So I act on the spur of the moment, so to speak. There is no premeditated plan, but something happens and it enrages me, or I act in a certain way. I want to kill a person and I proceed to kill that person. Now, the importance of that definition in this case especially is that if there's an error in persona, in other words, if I'm not sure, as in Oscar's case, who is behind that door, it is no defense. I still made up my mind to draw my firearm, fire 4 shots through that door with the intention of killing whoever is behind that door.
Which is why then Gerrie Nel was at pains to say, look, he did plan to do this. He went and thought about where the firearm was. He walked towards that door all the time shouting. He had enough time to make a decision if you accept, as the state contends, that in fact Oscar knew that it was Reeva Steenkamp behind that door.
Yes.
But if you put that aside and you go with his version, he then says he still can't get off because he knew there was an individual behind that door and in fact conceded that under cross-examination.
Exactly. And the gap that Gerrie Nel also has is there is no defined time limit to premeditated murder. You can plan it in a matter of 20 seconds, or as I explained earlier, in a matter of weeks or months. But that is where Gerrie Nel still says that it was premeditated murder. Okay, but we finished with murder dolus directus now.
Right.
Then you get murder dolus eventualis, which Gerrie Nel also referred to. Now that is where a person knows that if he acts in a certain manner, there is a possibility that someone will be killed through his actions. He reconciles himself with that fact and he still acts accordingly. And that is what Gerrie Nel is also saying, is that even if you acquit him on premeditated murder or murder dolus directus, surely you must acquit him on murder dolus eventualis.
So you must find him guilty, you mean?
Sorry, surely you must find him guilty on that, yes. Because surely you must have known that if you take your firearm and you discharge 4 bullets through a bathroom door, and it is your perception that there's someone behind that door, there is a very real possibility that whoever is behind that door will be killed. You reconcile yourself with that fact and you still act accordingly. And then Gerrie Nel still went even one step further and he said even if the judge acquits Oscar on those 3 different variances of murder, 3 yes, then she must convict him on culpable homicide because his actions were so negligent, and of course that is the negligent killing of another person, that he must be convicted. In that he thought there was, well, even if he thought there wasn't an intruder, his actions led to the person being killed, and he was grossly negligent in doing that.
I suppose this is the whole point, Judge, about closing arguments, because it ties up all these elements that seemed perhaps not to be as significant now, because you'll remember, of course, we spent a long time talking about the weapon that was used, talking about those bullets that were used, and if I pick up on Ulrich's last point there, he says, having that particular weapon, having those particular bullets, you would have foreseen the eventuality of what might then occur. So in a sense, Gerrie Nel has tied up almost every single possibility as far as making sure Oscar Pistorius goes away for a long time. Barry Roux, of course, is having none of that, is he?
Yes, and just to clarify what we've just been talking about, and all the other evidence about the hearing of a woman screaming and all that is really facts and factors and circumstances that are relevant to these core factors. So we must understand that even if you didn't have any other evidence and you only had what we've just been talking about, and the court accepts Nel's argument that it must reject Oscar's evidence, it would have to find him guilty. So as I said to you before, I think several times on this program, it really boils down to that. If Oscar's version is rejected, and Nel is arguing that it must be rejected, he must be found guilty.
But I have to ask you this, though. Barry Roux, as he began to lay out what he's going to be arguing for, what I expect will be all of tomorrow, says you can't ignore the timeline. He says the defense, or rather the state, hasn't at all bothered with the fact that there were differences in when different sounds might have been heard. And for the defense's case, that's a crucial thing, because if the shots went out at 3:12 or thereabouts, it then gives Oscar time to scream, which explains what the ear witnesses brought by the state might have heard. And of course, it accounts for the second set of sounds that the defense says happened because the cricket bat was beating down the door to break it open.
Yes.
Surely Barry Roux has a point there.
No, he has a point because it's critical to the defense, in terms of the defense perception, that Oscar must be believed. In order to have Oscar believed, he has to advance this argument that you cannot ignore the timeline. To the defense, it's important that the state witnesses be disbelieved or their evidence be rejected. I am saying, and I'm sticking my neck out, that at the fundamental level, all that is actually irrelevant. The timeline might be completely messed up between all these witnesses. if the court does not believe Oscar, or rather, if the court disbelieves Oscar as to why he killed Riva, the court has no option, for the reasons that Ulrich has set out, but to convict him. Whatever findings about the timeline there are and about the screaming and cricket bats and all that, that in a sense is actually not irrelevant, but sort of a red herring.
Okay, well, let's pick it up then. Ulrich Roux, you're a defense attorney. Put yourself in Barry Roux's big shoes, no doubt. How do you deal with what Gerrie Nel was saying today, that Oscar Pistorius was not only a weak witness, that he was mendacious? How do you deal with making sure that the court looks favorably on your client? I mean, where does Barry Roux go to from here?
We've said it from the beginning, and we maintain that throughout the trial, is that the trial was always going to be about Oscar's testimony. And unfortunately, it doesn't matter how much you prepare your client or witnesses, you cannot foresee how they will react in the witness box and how they will withstand the cross-examination. Now, it is, of course, everyone's perception that he was a weak witness, that he didn't testify well. Gerrie Nel outlined that he was evasive, he was emotional, he got angry with Gerrie Nel, he changed his versions, and all those reasons. But the only thing that the defense is left to do now is to stick to their version. And their version was that he made a mistake in shooting Riva, that he thought there was an intruder. He honestly believed that his life was in danger, and that the only way that he could act in order to protect his own and Riva's lives was to shoot whoever was behind that door. Now, they attempted to back that up by all the psychological evidence that was led and all the character evidence that was led on Oscar's behalf as well, that he'd gone through all these traumatic experiences throughout his life, and that that was the reason why he thought that his life was in danger. Now, to answer your question directly, it is difficult to deal with the way your client testified. It is, of course, and that testimony is on the record. But if I had to give them advice, it would be stick to your story. Do not attack the state's case as such now. Stick to your version and try and convince the judge that it is reasonably and possibly true. Now, he's already showed his hand and indicated that he's going to attack the police investigation of the matter. But I think we discussed it off air, that I don't think it is really material because of those reasons that we set out earlier. He picked up his gun, he killed whoever was behind that door. The fact that the scene was tampered with to an extent afterwards, after she was shot and killed, or interfered with, does it really have a big meaning? Is it really material? Do the timelines really play such a big part, as Judge Greenland said now? Those are the things that they need to consider, but they can only hammer on their case and their version.
Chris Greenland, if I may, Barry Roux says all those things are material. He says that what the state is choosing to ignore are material facts.
Can I put it this way? It's in the interest of the defense to subvert all the evidence that contradicts Oscar. The evidence before and the evidence thereafter. Because it then provides the basis for them submitting to the court. The only explanation you have of the killing is from Oscar. And for the reasons that our colleagues have often told us on the show, it's a reasonably possibly true story. You might not like it, but unless you can actually disbelieve him on jurisprudential grounds, you have no option but to acquit. So, in a nutshell, this is to reach a stage where where the defense can submit that the court can only go on Oscar's version.
How difficult is that, Ulrich, given that we now also have those lesser charges where Oscar Pistorius, I mean, by all accounts, has been found less than wanting?
Indeed, and Gerrie did refer to them at length during his closing arguments. And that was always a stroke of brilliance and a move of brilliance, in my opinion, on Gerrie Nel's behalf. Because fundamentally, that is actually character evidence. It has nothing to do with the incident on 13 February 2013. But by preferring the charges against Oscar in the manner that he did, he could lead that evidence, and he could create this perception of Oscar that he is gun angry, he is this individual who gets enraged quickly, he goes for his gun before he does anything else, and this was sort of the basis that he laid prior to dealing with the actual incident.
Yet we now have Barry Roux, if I may, Chris, we now have Barry Roux admitting that in fact his client may have been negligent. If that is the case, why then not at least accept that charge, that discharging of that firearm in that restaurant was not the right thing to do?
Certainly in hindsight, and it is 2020 vision, and we all have our opinions. One would expect him to plead guilty to those 3 charges, because if he did, then no evidence would have been laid on it, and the court would not have considered that evidence in dealing with the main charge.
Let's have you, Chris Greenland.
I had actually forgotten what I wanted to say.
Whilst you think about that...
But I'm not so sure that you're right when you say that Roux is accepting that Oscar might have been negligent.
Well, he said that. He said, I'm going to accept that he was negligent, but I don't think he's guilty.
I don't think he used the word negligent.
He used that specific word.
Okay.
What do you remember, Ulrich?
Okay.
He did. He said that he was negligent in accepting the firearm in Thatcher's restaurant. That is what he said. But Oscar's version there was that the gun went off by itself.
In fact,
and people
he said,
testified that it's impossible for that gun to discharge by itself.
He blamed Darren Fresco for passing the gun to him, knowing that it was loaded. He took absolutely no responsibility for it.
Yes, certainly Oscar's testimony on the 3 lesser charges left much to be desired.
So in the absence then of direct evidence, in the absence of another witness or a recording of some kind, presumably then what the court has to do is weigh up Oscar Pistorius' version and try and fit it to the facts that are not in dispute. Is that matching up so far?
Well, sorry. And then we had this, I think, a reference to exotic argument about possession and animus. That, yes, the defense will admit that Oscar had possession, but because he didn't have intention to possess, he actually wasn't possessing. And I'm very bemused by this argument. I know all about possession and animus, but I've never ever heard it being an attempt being made to apply it to these type of facts before.
So, Ulrich, my question, given all of that, given this issue of possession but no intention to use, given Oscar Pistorius' version matching it up with the objectionable facts, do we have, the objective facts rather, do we have a match?
No, I don't think so. Just to get back onto that point, that he said that he had no intention to possess the ammunition. But he also testified that his father had placed the ammunition in his safe. But then he also testified that him and his father hadn't had a proper relationship for the last 5 years. So it's just, again, Oscar's entire version regarding those 3 lesser charges, it is not reasonable. It is, in my opinion, not possible. And it's really going to have a great effect on his intention on that evening and the main charge, and the judge is going to have to consider it because that was evidence placed on the record and brought before court.
And Gerrie Nel will be supported on those facts in his submission that there is this characteristic that Oscar never wants to take responsibility. He's never accountable.
Well, if we talk about some of the doubts that Gerrie Nel was raising in terms of what Oscar Pistorius said about that night, the issue of the startle, the issue of hearing a sound, was it a magazine rack, was it the door, and the fact that he went to some length to show that there was no imminent danger. Oscar Pistorius has never been able to say this is what he saw that made him believe that that was the right course of action to take. If we go to the magazine rack thing, I mean, Gerrie Nel was at pains today again to point out the only way that magazine rack could have moved is if Riva Steenkamp herself moved it, and there is no suggestion that she did. Why or how does Barry Roux deal with that?
With considerable
difficulty.
You know, to my mind, whichever way you want to bake the facts, Oscar is at the door and he groups 4 shots. And this is important. because that's completely inconsistent with aspects of his case, like that the gun just went off and that he was terrified. You need a degree of efficiency and effectiveness to group those shots like that. And he knows that there's a human being behind the door. And I think that everything else is very, very interesting, as some other experts said on this program before. But really doesn't take the matter that much further.
Just to add on to that, Bongani, Oscar's version, as we've now said numerous times, was that he thought his life was in danger. He thought him and Reva's lives were in danger. He went to go get his firearm. He walked 6 meters down that corridor and he fired the shots through the door. Now, surely the question must be asked, when he fired those shots, was he then on the defense, protecting his life and Reva's life, or was he on the attack? Because a person who moves towards the danger and they will deal with a fight and flight scenario and all of that, still that needs to be considered. Why not immediately make sure where Reva was, immediately try anything else except advance towards the danger and shoot those 4 shots? And it ties up with, you know, is the importance of the magazine rack really, is it that important? Because look at his actions. Regardless of the sounds that he heard, look at the way in which he acted, and the judge will have to consider that, whether she's going to accept his version of self-defense or not.
Well, Gerrie Nel was quite specific. He looked at that photograph, I think it's photograph 56, with the curtains open and the different positionings of the duvet and the denims and so on, and he contends that actually that photograph is very much the scene, or at least how the bedroom was when the incident happened. He says all of the things that we've heard from Oscar Pistorius, in fact, never happened.
Yes, indeed. And I think he has a very valid point. You know, Oscar, during his testimony, he blamed the police for tampering and moving things around on the crime scene. He blamed his attorneys, he blamed his lawyers, he blamed his friends for lying, and again, that ties up with... Exactly. He blamed everyone else. He did not take any responsibility, and that is what Gerrie Nel again pointed out today. You cannot contest that photo of the room because you're just blaming everyone else and not substantiating it.
Bongani, I think as regards the scene, there were 2 points that Nel is making. Is that scene, as it is, shows that the lighting was better than Oscar was claiming, because Oscar said it was pitch dark because the curtain was actually open. That was the first point that was important. And he was also saying that Oscar was then tailoring his evidence to put his back towards where Reva would have been if she was in the bed. So that's the reason why he was saying that the question of the scene is important. So Oscar was altering things to say, no, the room was actually dark, and I acted in darkness.
Yeah, and I mean, I suppose also what he was trying to do throughout the day today was argue how, in his view, Oscar Pistorius was trying to buy time for Reva to leave the room without him seeing her. The idea of, 1 fan at the bail application and then 2 fans when he was on the stand. Gentlemen, it's been a fascinating day. It's been most absorbing. Thank you very much for staying with us. We had a longer session than we normally have, but you gentlemen have been kind and generous enough to stay with us in studio. Thank you, as always, for your analysis.
Thank you, Bongani.
All right, we're going to